Good afternoon, everyone, and welcome to today's webinar, Fair Work Compliance by Corinne West from Employsure. Today, you're listening in using your computer speaker system by default. If you would prefer to join over the phone, select telephone in the audio pane and the dial-in information will be displayed. You'll have the opportunity to submit questions to Corinne by typing them into the questions pane on the control panel. You may send your questions in at any time and we'll address them during the Q&A session at the end. To give a brief introduction on today's presenter, Corinne holds Bachelor degree qualifications in law and business with a special interest in employment law. From her previous role as a generalist human resource manager for 170 staff, Corinne has extensive experience in policy development and implementation, performance management, return to work coordination, and strategy development for effective staff performance. Her ability lies in being able to understand and relate to the practical realities facing small business in effectively managing their staff. Corinne's colleague Scott Gully is also joining us for today's webinar and is available to chat with you one-on-one after the webinar to discuss specific employment relations or work health and safety issues your business may be facing, and he will detail how Employsure can assist you and your business. I'll now hand you over to Corinne and Scott.
Thank you, Kate, for that wonderful introduction, and good afternoon, everybody. As Kate mentioned, my name's Corinne and I am a field consultant with Employsure, and today I'm joining you from my home office in Newcastle, New South Wales. To give you a bit of an idea of what my role entails at Employsure, as a field consultant, I go out each day and visit small to medium businesses such as yourselves and look at how we can make sure you're being compliant with the fair work obligations and also making sure that we're getting the maximum performance out of our workforce. In doing that, I complete a full gap analysis and compliance review of the business and complete a full documentation set for your business, including employment contracts, policies, procedures, and additional tools and resources. So day in, day out, I work closely with small businesses to come up with some solutions as to how we can not only be compliant with fair work, but also how strategically this is going to benefit your business. So as we mentioned, today the purpose of today's webinar is to have a look at what obligations you as employers have under our current workplace relations system. Now, just bear with me. There we are. Here's our next slide now. So as I mentioned, we want to have a look at our workplace relations system here in Australia. And to be quite honest with you, it is very complicated and it's not very easy to navigate, which means it is quite difficult to understand unless you are an expert in this field. What I find talking to a lot of small business owners is they're quite often not aware of where to go to determine what your employees' entitlements are. To give you a little bit of a breakdown, we first look to the Fair Work Act, which is an umbrella that provides that minimum safety net of entitlements for all employees, such as leave and protection for unfair dismissal. However, underneath that umbrella, we have over 120 modern industry and occupational awards that regulate minimum conditions of employment in certain industries. So this looks at your minimum rate of pay, ordinary hours of work, and how penalty rates are calculated. So these are matters pertaining to payments and wages that have a significant impact on your business. Underneath that, we also have a whole raft of state-based legislations around workplace health and safety that we need to comply with. And although today the focus is on the Fair Work Act, Employsure can also help you with your compliance in work health and safety, which my colleague Scott will brief to you shortly. Now, what I find is generally business owners become familiar with this employment relations system because something has gone wrong. They've been exposed to an authority like the Fair Work Ombudsman for an underpayment claim, or potentially the Fair Work Commission because the employee has made an unfair dismissal application. These applications are more common than we think, and in all the people I talk to, a lot of us have experienced that before, and all of us on the phone today are on the same side. So when it comes to our Q&A shortly, please feel free and open to ask any questions you might have about these otherwise sticky issues. Now, under that umbrella safety net of the Fair Work Act, we have our key employee entitlements, otherwise known as the National Employment Standards. So I want to draw your attention to a couple here that we might not be familiar with. Firstly, compassionate leave. Now, compassionate leave, otherwise known as bereavement leave, is separate to a sick leave entitlement. And when we're talking about our permanent employees, all of those employees are entitled to 2 paid days on each occasion when an immediate household or family member dies or suffers a life-threatening illness or injury. Now, to give you an idea of what is included in the definition of a household or family member, the Fair Work Act defines this as a spouse, a de facto partner, child, parent, grandparent, grandchild, sibling or child, parent, grandparent, sibling of the employee's spouse or de facto partner. So in saying that, to give you an example, and to be honest, it's a horrible example and I hope it never happens, in the situation where my husband's grandfather suffered from a stroke, which we would define as a life-threatening illness. On that occasion, I would be entitled from my employer for 2 paid days compassionate leave. If, in the instance, a few weeks later, unfortunately, his condition worsens and he passes away, I will then be entitled to another 2 days paid compassionate leave. And as we discussed, this is separate to our sick leave entitlement, and there is no cap on how many days a year people take. Now, obviously, we hope for everyone's family and work-life balance that people don't necessarily have a need to take this, but it is an entitlement that the employee have this. Having a quick look at personal and carers leave, which we more commonly know as sick leave, a full-time employee is entitled to 10 days per year, and this does accumulate year on year, but is not paid out when leaving employment. Having said that, under some industries, such as the mining industry, it can be payable. And again, this is where those modern awards can dictate industry-specific rules. We also have, under these key employee entitlements, a necessity to issue a Fair Work information statement to our staff. So what this is a statement that forms part of the National Employment Standards and contains information on these areas of the National Employment Standards, awards, rights of association, and the role of the Fair Work Commission of Fair Work Ombudsman. So we must provide each employee that commences employment with the business a copy of this statement, and also we need to retain a copy to prove that we've given them a copy of this statement. So some record keeping obligation there as well. Now, for those of you who are not familiar with this, we need to be aware that this is an important compliance issue under the Act, because there can be individual fines of over $10,000 or up to $54,000 for a corporation. So something as simple as issuing a double-sided fact sheet can unfortunately get us in a little bit of hot water. So we definitely want to make sure that we're keeping abreast with what our compliance obligations are. Now, we did mention that National Employment Standards and those key employee entitlements we looked at on the previous slide form that umbrella and that safety net under the Fair Work Act. So what we want to look at is how that interacts with other employee entitlements, and how do we find out what these are for your business and their employees. So essentially, if we look at this pyramid on the screen, the bottom there is the Fair Work Act, which we've said before is that umbrella and that minimum safety net. We then have awards that'll be applicable to your business. Now, you may only be covered by one award, you may be covered by several awards, depending on the type of business, your business activity, and the type of employees you engage in it. And this is something that myself as a consultant can assist you in determining. Now, as well as the modern awards, we also want to have individual contracts of employment for every employee in the business. And these contracts are going to state the terms and conditions of employment. So while this contract cannot contravene the Act, we can use it as an employer's best friend, I like to say, to supplement and enhance those entitlements to get a little bit back. So in a contract, yes, we are going to spell out what they are legally entitled to, but how about we also put some contractual obligations in there regarding confidential information, regarding termination of employment, regarding intellectual property. These are the kinds of things we want to be putting in our contract to bolster your strength as an employer to try and protect your interests. Because as we can see, there is a lot out there swinging in favour of the employees. And a lot of the times it can be impractical to meet 100% compliance with all these issues I'm raising. So how can we most effectively draft employment contracts to give you as much as we can? In talking about employment contracts, one thing we want to determine first and foremost is what type of employment an employee is engaged under. And while this seems like a pretty basic question, in a small business where people are under flexible working arrangements, everybody jumps in and helps out, and you know, we're very much in a service industry, you know, relying on customers, the lines can blur here. So in looking at full-time employment, it's most appropriate to engage a full-time employee when they are your key staff, when you have 38 hours a week to offer them, and you're able to obviously have those entitlements with annual leave and personal leave. Now, part-time employment after that is permanent employment like full-time, but we're working on lower hours, which is less than 38 hours a week, and those entitlements accrue on a pro-rata basis. Another type of employment we can engage is fixed-term employment. So this is permanent full-time or permanent part-time, but having essentially an expiry date in that contract. So as a business owner, if you're not sure where your business is heading in 12 or 24 months and you do not want to overcommit when it comes to employment and financial obligations there with entitlements, we can put an end date on that contract. I like to use these kinds of contracts where covering maternity leave, where we may be engaging an apprentice. These contracts can definitely help you, again, not overcommit and get the most out of that relationship. In terms of casual employees, the organic definition of a casual employee is that seasonal, vocational, irregular style work. So a casual employee should have no guaranteed hours of work. They should not be on your regular roster, and they do not receive paid leave entitlements. However, that quite often isn't the case for a lot of small businesses. A lot of small businesses have casual employees that may have been engaged with you for 1, 2, maybe even 5 years tenure under their belt, and they're completing rostered shifts week on week. They may come and go depending on if they're a university student or they've caught the travel bug, but generally when they are here, they're on your roster week on week. Now, this type of employment can get a little bit scary and can blur the lines here and cause some risk for you as an employer. Because while a casual employee doesn't have the entitlements of a permanent employee to make claims regarding unfair dismissal in the Fair Work Commission, they can be deemed a permanent employee. So to look at this as a test as if it looks like a duck and quacks like a duck, it's probably a duck. If you have a casual that's rostered side by side with your permanent staff members that has a significant length of tenure with you and forms part of your core staff, they may very well be deemed a permanent employee, which will leave you liable for those entitlements. So it's always important to make sure that our employees are correctly classified to their most appropriate employment type. Now, on the right-hand side of the screen here, you'll also see I've listed independent contractors. Now, I hope a lot of you have picked up that this one's actually a little bit of a trick because they are not an employee. Having said that, I would still want to put a contractual agreement in place for that business-to-business contractor relationship. So again, there can be no confusion or avenue for this contractor to try and claim that they were an employee and again access those employment entitlements. This is what we call sham contracting, and it's something we see a lot of in more like trade-style industries, where someone's working regularly for you on an hourly rate and invoicing you as such. We do need to be careful here that those lines don't blur into an employment relationship, and having some comprehensive documentation in place that I can assist you with is going to be the best way to protect yourself here. I want to move on now and look at a few risks we do need to be aware of that exist under the Fair Work Act, and we are seeing cause a lot of problems for business owners. So the three main risks I want to touch on here are unfair dismissal, adverse action and discrimination, and bullying and harassment. So firstly, let's have a look at unfair dismissal. So a dismissal under the Fair Work Act will be deemed unfair unless there is a valid reason and a fair process has been followed. So the first thing here you can see in the wording of that is, as an employer, you are treated as guilty until proven innocent, that you can prove that it was not in fact unfair. And of this tree, we have two key branches that will be, was there a valid reason for termination? In an example where an employee once turned up 5 minutes late, potentially not a good enough reason for termination. If an employee turns up and committed some act of workplace violence, yes, potentially that is a reason for termination. So looking at whether or not the reason was harsh, but also looking at whether or not a fair process has been followed. And this is what we're seeing have employers come undone more and more often. I'll give you an example from a 2014 case that we saw go through the Fair Work Commission. We had a truck driver that was terminated for urinating outside the entrance to a customer's warehouse. Now, although that is a valid reason for termination, in this case, the employee was awarded $16,000 because the employer terminated the employee without giving them an opportunity to respond to this allegation or to show them the CCTV evidence to the employee. So in this instance, they've gotten the customer complaint and they've given them a call or had a verbal conversation to say, mate, you're done, see you later. Because there was no formal disciplinary meeting held where that employee was asked to explain their actions, he wasn't able to explain that he actually had diabetes, which meant that he suffered from urinary urgency. And if they did, the employer would have needed to take that into consideration before making a decision. Now, whether or not that would have affected the decision itself, we'll never know. But the fact that alone the employee was not given the opportunity to respond meant that he was awarded $16,000. So again, not only are we looking at the reason for termination, we're looking at our due process and our fair process has been followed, which we'll look at what that entails a little bit later on. Now, we do need to note though, it's not all bad news. The Fair Work Commission's jurisdiction for unfair dismissal claims is restricted. So if you are a small business with less than 15 employees, an employee would need to have 12 months continuous service or more before making a claim for unfair dismissal. So no matter what your probation period might say in your contracts of employment, an employee cannot access that court unless they've had 12 months service. If you're a medium or large business where you have more than 15 employees, that threshold drops to 6 months. So again, that employee still needs to have 6 months tenure before making a claim. This jurisdiction also isn't open to anyone that is earning more than $142,000 per annum. And it's also not available to casual employees. However, as we discussed, if we have regular and systematic casual employees, we do run the risk of them being deemed permanent and being able to access this remedial action. It can also be used where someone is resigning it could be considered a constructive dismissal. So have we followed a process to confirm all steps in that resignation? Have we completed an exit interview? These are the processes I want to be following to protect yourself as an employer. I mentioned probation periods before, and it's advised you use these wisely because these act as your safety net as an employer, almost like try before you buy. So we can terminate employees quite easily during this period of time without worrying about a complicated process side of things. Moving on to adverse action and discrimination. Now, we like to call this kind of claim the sleeping giant of the Fair Work Act because it not only protects current employees, former employees, but also prospective employees who haven't even gotten a job with you yet. And it's something that not a lot of employers are familiar with. So adverse action, this term is used synonymously with the term general protection. And essentially, to sum it up, every employee is entitled to protection against an employer taking adverse action on a prohibited ground. So let's break this into two parts and firstly ask, what is adverse action? Basically, as an employer, you cannot take any action to the detriment of an employee because of a prohibited ground. So when we're talking about action, yes, it includes termination, but it might also include a change in their rostered hours, disciplinary action, or potentially them missing out on a promotion or training opportunity. In terms of what is a prohibited ground, firstly, we look at discrimination as defined under the Anti-Discrimination Act. So we're talking about your race, your sex, your sexual orientation, your skin colour, your religion, all of these protected grounds. But as well, we're also looking at a protected ground being the exercise of a workplace right. So if an employee has taken sick leave, if they have questioned their pay slip, if they have requested flexible working arrangements, you cannot take any action to their detriment for those reasons. Another protected ground is if they're off based on an injury or workers' compensation. So if someone has lodged a workers' compensation claim, no action can be taken to their detriment. So as you can see, this is a very broad ground that we need to be aware of. A few concerns I have here is that there is a reverse onus of proof. So if an employee was to jump online, fill out an online form to say that they have suffered adverse action, you as an employer are basically guilty until proven innocent. It's up to you to show that the action you took was not connected to that prohibited ground, which is why I stress the importance of process and documentation. If you are having a chat to somebody about their rostered hours, or you're having a chat to someone about their performance, following on from that meeting, we want to be emailing them or issuing them a letter that confirms what was discussed, what the outcomes include, so that when they try to make a claim suggesting it's something different, you can prove that this was within your right as a business owner to take this kind of action. So we really, really need to be careful here to cover ourselves because these claims are on the rise. What we see as well in this jurisdiction is that compensation is uncapped. So we could get up to the millions when it comes to compensation. Having said that, this doesn't mean that we can't discipline our employees or we can't effectively manage our employees. It just comes down to having that evidence around that process. So if you have policies in place that say how staff may be managed, what the expectations are, we're showing that this was communicated to our staff and this was an expectation and that it wasn't because this person was being singled out for any individual characteristic. Recently, we've had a case go through where an employee claimed she was terminated because she made a bullying complaint, which again is the enforcement of a workplace right. However, because the employer could show the records of meetings that where they've discussed their poor performance and that they had followed their performance management policy that was in place, the employee's claim failed. So again, these policies really do act to protect us. Moving on to bullying and harassment, and this is something I think we're familiar with because unfortunately it is more common in the workplace than most of us think. Now, bullying and harassment has always been protected under work health and safety legislation. But since 2014, workers are able to make claims through the Fair Work Commission directly. In order to make a claim, it's an online form again that costs $67.20. So you can see that it is very accessible for our employees. Now, why training and policies are so important here is because, again, jumping back to that process side of things, you know, if you have job descriptions in place that say, here is exactly what's expected of you, that you've given people training not only on bullying and harassment, but how to do their job, these are going to limit how an employee can make a claim. Now, bullying and harassment, we use these words synonymously, but for the sake of legal definitions, they are separate terms. So to look at bullying, we're talking about repeated unreasonable behaviour against somebody at work that creates a risk to their work health and safety. Now, these days, we're seeing the definition of bullying extended when we're talking about at work. We could be talking about Facebook messages that are sent to employees outside of their work hours. We could be talking about excluding them from a staff social event. We could be talking about micromanaging an employee. These are textbook definitions of bullying. Harassment, on the other hand, it needn't be repeated. It can be a one-off instance. And we're talking about unwelcome conduct that offends, humiliates, or intimidates a person. So harassment is quite often used when it comes to ethnicity, race, and gender. So it needn't even be directed at the employee, but if someone was making a racist joke in an earshot of an employee, not even that identified as that race, that is considered harassment. So again, having policies in place as to what is and what isn't acceptable workplace behaviour and training our staff on this is so important. Now, I know I sound at the moment like I am a stickler for the rules and I am nitpicking, but what we see is that this positively affects a business's bottom line. Imagine if all the staff stopped gossiping, they got back to work, they didn't muck around with making rude jokes or anything like this in terms of conversations. Your productivity in your business is going to go up because everyone's got their head down, their bum up, and they're focusing on their work. So where we are implementing and enforcing these policies, it does actually have a positive effect on the business, not only because you're not left having to defend yourself against these claims or investigate these claims, you know, you're not wasting resources on this process and we can all get back to work. And that's why, again, it is so important. Now, I have discussed a lot about the risks, but we do want to look at how we mitigate those risks, because it's not impossible. And once someone like myself comes in and sets up that framework for you, it's really easy to manage and it can really have a positive effect on our staff and our workplace culture. So, as I mentioned, we are giving equal weight in the Fair Work Commission to whether a dismissal was unfair or whether or not we followed a fair process. So what does this fair process look like? So if we're talking about disciplinary action for performance-based issues, so if someone is continually not meeting the performance standards, that might be key performance indicators or duties listed on their job description, we want to be issuing a letter to the employee for the reason for the disciplinary meeting. So information contained in this letter, we want to tell them the time, the date, the location of the meeting. We want to give them at least 24 hours absolute minimum notice. We need to invite them to have a support person of their choosing at the meeting, which may include a union representative. And I will touch on that point as well. The support person is exactly that. They're not there to advocate on the employee's behalf. They're simply there to show their support, to act as a witness, and potentially pause or adjourn the meeting if things get heated. So when we have our meeting, we do want to explain the role of the support person to the support person. But jumping back to this letter in the first instance, we want to spell out what we are there to discuss, any issues, any allegations, and any potential disciplinary action we are considering. If we are considering termination, we need to notify them of this. We also would like to include a sentence to say, if you're not going to show up without reasonable justification, that we can make a decision in your absence. Someone's not going to play ball and come to the table, well, there's only so much we can do. During that meeting, when we're holding that meeting, as I mentioned, we want that support person there. I always want to make sure they bring in someone of their choosing, or if not, if they choose to come to the meeting alone because they might be embarrassed, I always ask then and there if they would like to grab someone else from the business to sit in, because again, you want to confirm that you have let them have that workplace right. During the meeting, I like to look at these meetings as an information gathering session. You cannot turn up to these meetings with written letters showing that you've already confirmed that they're going to be terminated, because you're not showing fair process if you turn up to a meeting with a typed letter, because you're showing that you've already made your decision. So during this meeting, we discuss the allegations and put the evidence towards them and find out what's going on with them. Why is this happening? What can we expect moving forward if they're to stay on our team? We want to be probing and asking the right questions in the right way. And that's something as well that my team can help coach you on step by step through the process, because it is a fine art holding these otherwise difficult conversations. So from this meeting, we want to get as much information out of the employee as possible, and we don't want to make a determination of what the outcome will be then and there. We want to adjourn it and potentially meet back up the following day, or confirm over the phone or via email what the outcome of the meeting is. And again, the reason for that is that you are showing due consideration for the information they provided you during that meeting. In an instance where we have spoken about it being a performance-based issue, if they're not meeting their KPIs, we need to give them an opportunity to improve. So we talk to them about, do you need any additional tools, training or resources to be able to do your job? Because realistically, none of us want to be in a position where we have to fire someone. So if we can get them back on track, that's going to be the best possible outcome from this meeting. And they will be able to see that you're invested in them, and hopefully in turn show you the respect and dedication that you and your business deserve. Having said that, obviously in not every situation we're going to provide the employee an opportunity to respond. To improve. I've mentioned before that in a situation where an employee has taken part in some workplace violence or any other absolutely despicable act, we're not going to give them an opportunity to improve and to do it again. They are a risk to the environment, and most likely these options will result in termination. But again, we still do need to follow this due process, and that's something step by step we'll draft the correspondence, we'll work out with you. Now, I have spoken a lot about all this mythical paperwork that we need, and I know at this point in time it probably does sound quite difficult to manage, but honestly it's not. To give you an idea of the process I would recommend and the process that I put in place for the businesses I consult with and I work with, we want to get it right from the start. So when we are hiring and onboarding or recruiting our new staff, we want to spell out from day one what are the expectations of work. To be quite frank with you, I quite often look at these policies as them needing to be idiot-proof. because the way the Fair Work Commission is working at the moment is that unless we have it written down on paper and effectively communicated to our staff, it is difficult to performance manage our staff on. So setting that framework up from day one is setting those clear expectations and giving the employee every opportunity for success, so then we don't have to step on eggshells when it comes to performance managing. So through an induction process, I think an employee should get an employment contract regardless of their classification, and they should also be given a copy of the company's policies and procedures. I would also like to see the employee issued with a job description. Now, obviously, these job descriptions will change from time to time as roles in the business evolve and change and as an employee upskills. Our documents that are kept separate to our contract are flexible, and this is something we'll touch on shortly, to make sure that we do have the discretion of employers to change this as we see fit. So for every induction process, we want to be giving our employees a contract, policies, and job descriptions. We want them to sign off on it and return a copy or have a copy of their signature with these documents on file. That way we're set up and we can begin effective performance management immediately. When it comes to contracts and policies, I believe they're important because it both manages the risk to you as an employer and it helps manage employees. So when I say it manages the risk when we're talking about the claims and the issues we touched on before, the contracts and policies create certainty around the role. So it's telling me exactly what's expected of me. It's obviously ensuring that you are compliant under the legislation. It provides protection for you, especially in the instance where you're spelling out a termination clause that comprehensively defines how and why an employee might be terminated. Again, you're already setting yourself up, showing this fair process that they have been informed of this information. And using our probation period wisely, again, will help protect us against claims and better manage that risk. In terms of the management of employees and how this effectively helps us do so, it sets those expectations from day one. So there's no uncertainty for the employee to go, oh, I didn't know. You know, ignorance is not bliss. You've spelt it out from day one, and we can expect key performance immediately. And from demanding satisfaction, we can improve our productivity. I personally think it also has a positive effect on staff morale. Speaking from my own experience in former jobs, I felt a lot more at ease when I have had documents detailing what's expected of me, because again, there's no uncertainties and there's no worries. I know exactly what's required. It's spelled out in black and white, and I too feel safe and protected because of that. Now, we have discussed contracts and policies a lot, but what is the difference when we come down to it? Our contracts are going to be those legally enforceable terms. So it's a legally enforceable document that's signed off with the employee's consent. It's going to confirm those legal terms and conditions, and I like to look at it as a set and forget. Unless they're changing roles or employment structure in your business, you know, that contract stays there, it governs the relationship, and that's the end of that. Whereas our policies are more dynamic, they're discretionary. They, as an employer, you can put them in place, change them in place, remove them at your discretion whenever you see fit. Obviously, the only caveat to that is the employees need to know about it. They need to be given a copy. It might be on your notice board. They might get emailed copies. It might be in a staff diary or memorandum to communicate those expectations. Employees aren't necessarily required to sign off on it, but it's always good to have an acknowledgement form just to confirm that. So, as an example, if we talk about an employee's annual leave entitlement, our contract is going to stipulate what the annual leave entitlement is. So for a full-time employee, you will be entitled to 4 weeks annual leave in accordance with the Fair Work Act. But our policy is going to say, if you want to access your paid annual leave, you need to follow these steps. How much notice do you need as an employer? How do they go about requesting leave? Do they fill out a form? Do they raise it in staff meetings? Do they email you details? You know, we want to spell out all of these bits and pieces to make sure it has a limited impact on the business. And it's really important as well to keep these policy documents separate to a contract, because we quite often see employers who have given employees maybe a letter of offer, a letter of engagement, and over the years we've had bits added to it, amended it, edited it, and it's become this quasi-contract policy style document, which does question its enforceability. But also, the contract is a contractual obligation that works two ways. So if you were to have something listed in your employment contract as simple as you will be paid weekly on a Friday, and on one pay week because of a public holiday you decided to pay on a Thursday, you as an employer have breached your contractual obligation. So it's so important to make sure we're spelling this out. Now, in terms of Employsure, and I've mentioned previously about how we can assist, I'm going to hand over to my colleague Scott to give you a little bit of a rundown as to how we can help you put this framework in place. So Scott, over to you.
Thanks, Corinne. Great presentation as always. Great to get a small insight into your wealth of knowledge there. Hi everyone, thanks for joining the call today. As Kate mentioned at the start of the webinar, my name is Scott Galley. I'm a Business Development Manager here at Employsure. My role involves meeting around 800 plus businesses every year, providing them with help and support with any employment relations or work health and safety queries they may have, as well as introducing them to how Employsure can support and protect their business. So for those of you who don't know, what does Employsure do? So a little bit of background firstly on Employsure. Employsure are a relatively young business, been around for around about 6 years. In that time, Employsure have grown from 0 clients to around about 15,000 clients currently across Australia. And we have over 400 employees in our business, so we've seen quite significant growth over that 6-year period. We're a membership model, so our 15,000 clients are members of Employsure. We charge a monthly membership fee, which is dependent on the size of your business. 4 main pillars of Employsure's membership service. So top left there is what we refer to as compliance. So Corinne did touch on that, but Corinne or one of Corinne's colleagues visit our new clients and conduct a full review of their documentation and processes they have in place, and then provide them with the foundations for ensuring that their business is fair and safe by providing tailored employee contracts, policies, additional stationery, and we also help obviously embed these into your business to help protect from any future issues with non-compliance. Second part of our service is advice, which is quite self-explanatory, but all of our clients have 24/7, 365 days a year access to our team of skilled advisors that are based in Sydney and Perth. They can call through really around any question at all relating to their employees, so it could be a simple pay raid, a public holiday, maternity leave, disciplinary issue, performance management. Really the list is endless. We also back that advice service up with supporting documentation, so if our clients do need to provide a written warning, for example, we'll write that on their behalf. Any termination letters, redundancy letters, things like that are also written by us for our clients. Third thing there, or third and fourth things really go hand in hand, but they're representation. Which basically means that Employsure indemnify the service that we provide. So in the event of a claim against your business, our in-house specialists will advise you through the process. And if the matter proceeds to court, our legal partner, Spark Helmore, will provide professional representation. And that's all covered with quite a unique insurance policy that we have, which is underwritten by QBE, which covers our clients up to $2 million a year in legal fees, associated expenses, compensation, etc. So a great way of getting some support ongoing for your business around fair work compliance. The model also applies for a number of our clients that we help with their work health and safety obligations. So the model is exactly the same, but it's obviously relating to the Work Health and Safety Act 2011 rather than the Fair Work Act 2009. But the compliance, the the advice, the insurance and representation also applies for that side of our membership service. So our clients get a choice of being a member for one, the other, or both. As part of the everyone joining the webinar today, we'll be offering some one-on-one consultations. We will have a time for a Q&A now, which I think Kate is going to facilitate. So please feel free to put any questions forward to Corinne or myself. We'll be happy to answer those now. If you've got anything a little bit more sensitive or you don't really want to share in this forum, then obviously I'll be more than happy to give you some ongoing support and give you a one-on-one consultation where we can maybe have a little bit of a more detailed conversation specific to your business. So I'll hand over to Kate and hopefully you've all got some questions.
Thanks, Corinne and Scott. That was really informative. There don't seem to be any questions so far. Everyone's a little bit shy. If you do have any questions after the webinar, as you can see, Scott's details are on the screen. Tomorrow you'll receive a follow-up email with a link to view the recording of today's webinar and also a link to view the slides as well. Still no questions. So we might wrap it up there. On behalf of Corinne, Scott and Appa, thanks everyone for joining today and have a great afternoon.
Thanks everyone.
Thank you everyone.
Thanks, bye.